Good evening, everyone. I'm here to discuss the civil law bar questions and answers for year 2019 from numbers 6 to 10. Starting off with question number 6. Name at least two exclusions from the following property regimes as enumerated under the Family Code. A. Absolute community of property, and B. Conjugal partnership of gains. Before we answer that question, it is right we go back to our topics or subject matters discussed in persons and family relations regarding the four types of property relations. So in the family code, property relations are also referred to as property regimes are divided into four types. First, you have the complete separation of property. Second, you have the property regime of unions without marriage. Third, you have the conjugal partnership of gains. And fourth, the system of absolute community. While these four types of property relation may not apply to you now, it will play a significant role once you plan to get married or you are getting married. The property relations have to do with the law that applies to the properties and other valuable things you accumulate over time, because since you are already working at this point, or maybe you're still a student but you're acquiring properties, they include your cars, your jewelries, and real estate. So it's very important to know these property relations because there are some details about property relation that you need to know, whether you're a legal wife or a legal husband or partner. Now, the Family Code of the Philippines took effect, if you remember, on August 3rd, 1988. And since that day, the absolute community of property have governed married couples. However, this property regime will only apply if they do not agree on any other regime before getting married. And the agreement before the wedding is referred to as marriage settlements. We also discussed that briefly in a short while. Before August 3rd, 1988, the couples who got married without preparing marriage settlements beforehand are covered by the conjugal partnership of gains regime. So that's the third one. If the husband and wife agreed to complete separation of property in their marriage settlements, then they have also executed that before the wedding, then the property regime cannot be executed after the wedding. So it cannot be changed after the wedding. On the other hand, if the property regime of unions without marriage is executed, two kinds of unmarried couples living together may qualify under these categories. First is those who are not legally married, because some of them may have, or some may have legal impediment or incapacity of either or both of them. And of course, those who are legally capable of marriage but hasn't really gotten into deciding to get married yet. While both of these property relations are governed by the same property regime, each of them has different rules. And under the general law, a man is only allowed to marry one, and one time, or one woman. And if the man is already married to one and the marriage is still in effect or still subsists, then the other woman cannot be married to him. However, just because the other woman cannot be legally married does not necessarily mean that they do not have any right on the properties that they have accumulated together. According to the law, there are also legal rights of the other woman that need to be taken into consideration. Now let's proceed to defining each one. The complete separation of property is the first one. And under this, as the name suggests, each spouse retains individual ownership of the property that they had brought into the marriage, as well as the property that they had individually acquired thereafter. So this happens prior to the marriage and even after or during the marriage. The separation of property may refer to present or future property or both, and it may be either total or partial separation of property. Now, in the latter case, the partial separation of property, the property that was not agreed upon to be separate shall pertain to the absolute community of the spouses. So it's very important that either of the spouses or both of them, if they really want a separation of their properties, must be indicated therein. And there must be a settlement, of course. Now, the ability or the liability of the spouses as to creditors for family expenses shall, however, be solidary. So despite the fact that they have complete separation of property, they are still solidarily liable to their creditors, especially when it comes to family expenses. Now, under the system of complete separation of properties between the husband and the wife, each spouse shall own, dispose of, possess, administer, and enjoy his or her own separate estate without the need of the consent of the other, since it was expressly stipulated beforehand, so neither one of them has to have a say or has to be needing a consent of the other. This means that each one of the spouses owns his or her exclusive properties from both the present and the future property, including the ones they have already owned prior to getting married. And if the couples choose this property relation or regime, the means for supporting their family is through the use of a common fund. The contribution of each part will depend on their income capacity. Now, to each spouse shall belong all the earnings from his or her profession, business, or industry, and all fruits, natural, industrial, or civil, due or received during his marriage from his or her separate property, because this is to each his own, right? And both spouses shall also bear the family expenses in proportion to their income. So, for instance, if spouse A or the husband has an income, for example, of 1 million a year, and the spouse B or the wife has an income of, let's say, 500,000 a year. So then each share must be proportionate to their income in terms of their family expenses. So it cannot be said that spouse A or the husband shall have lesser share because he has a bigger income compared to the wife. So it must be in proportion to their income. So if it's 50-50, they have to share the expenses of the family, especially when it comes to how they are going to maintain their family, their household, and all those other expenses pertaining to the family in proportionate to their income. In case of insufficiency or default, however, due to probably losses in the income of either or both, it must be according to the current market value of their separate properties. Now, again, as I've mentioned, the liability of the spouses as to creditors for family expenses shall be solidary, however, and the separation of property may again refer to either future or the present or both properties. Now, further, it may be also total or partial separation of property. And again, there has to be a stipulation that, okay, it's going to be a total separation or this is going to be partial. Otherwise, the assets not agreed upon as separate shall be part of the absolute community. It is also important to note that in complete separation of property, there is what you call the non-convertible of this settlement or of this property relation into conjugal partnership of gains during marriage. So for instance, if prior to the marriage, you've both decided you will have a complete separation of property as your relations or property relations. Now, if you got married and into your marriage or during the marriage itself, you decided you wanted to have a conjugal partnership of gains instead. Now, that is void because you cannot convert. If you already agreed upon complete separation of property beforehand, you cannot convert your property relations into conjugal partnership of gains anymore. And of course, if in the marriage settlement, the future spouses agreed again on the system of complete separation of property, it cannot be converted into conjugal partnership of gains. The conjugal partnership and absolute community of property can, however, be converted into the separation of property regime during the marriage, provided there is judicial approval. Okay, so that's just the catch you cannot revert or you cannot change to conjugal partnership of gains if you've already agreed on the complete separation of property before your marriage. Now, if during your marriage there was no, or even prior to the marriage, there was no agreement that you are going to have a complete separation of property, and so after April 3, 1988, it's already um, the property regime that already governs all marriages this time, especially with property relations, is the absolute community of property. Now, in the middle of your marriage, you can convert the same or your property relations into separation, complete separation of property. But this time, you will need judicial approval, so you will have to go to the court. Such judicial separation of property may either be voluntary or for sufficient cause. So, again, there is a way that you can change from the conjugal partnership and absolute community of property to complete separation of property. So, kasi there are times that, for example, celebrities, no, they decided na, oh, they didn't actually agree upon any property relations prior to the marriage, and then in the middle of their marriage, they decided, oh, the woman is earning more than the man, and they both decide, okay, it's better if we have a complete separation of property. Then you have to get judicial approval for that. And there are processes for acquiring judicial separation of property, which we will discuss in a short while. But it is also important to know that the future spouses may adopt the regime of complete separation of property in antenuptial agreement. So we will also be discussing a little bit about antenuptial agreement and what is it, because I bet you have already forgotten or probably needed refresher of this. Let's talk a little about the process of acquiring judicial separation of property if you are to change your property relations in the course of your marriage. Now, first, the spouse may jointly file a verified petition with the court for voluntary dissolution of the absolute community or the conjugal partnership of gains and for the separation of their common property. So these are the steps that you need to take. For instance, your property relations during the marriage was absolute community or conjugal partnership, and you want to convert it into a separation of properties. Second is if there are creditors, all the creditors of the absolute community or the conjugal partnership of gains, as well as the personal creditors of each of the spouses, shall be listed in the petition and notified of the filing thereof, because these are parties of interests. Now, third, the court shall take measures to protect the creditors and other persons with pecuniary interests, those who might benefit if in case there's a separation of property and they needed to claim some amount of money or property perhaps from each of the spouses or either or both of them. Next is, once the separation of property has been decreed by the court, the absolute community or the conjugal partnership of gains shall be liquidated in conformity with the family code. And during the pendency of the proceedings for separation of property, the absolute community or the conjugal partnership shall pay for the support of the spouses and their children. Of course, because there are expenses of the family that needed support. So you still need that fund from your previous conjugal partnership or your absolute community. Now, lastly, after the dissolution of the absolute community or of the conjugal partnership, the complete separation of property shall apply. And the petition for separation of property and the final judgment granting the same shall be recorded in the proper local civil registries and registries of property. So, civil registrar and in the ROD, because you have properties pertaining to personal and real that are affected in the change of your property relations. As I've mentioned earlier, some of the couples, prior to their wedding and their marriage celebration, they usually have antenuptial agreements, or what is commonly known as a prenuptial agreement. This is very common, especially amongst couples who belong to well-off families or are by themselves already earning a lot, and probably to protect their own invested interests, because just in case there might be a dissolution of marriage happening in the far future. Now, this is a legal contract entered into before a marriage that stipulates certain details about the marriage and what would happen if in case the marriage gets dissolved. And most frequently, this agreement outlines specific financial matters because, as I've said, either both of the spouses are earning income very well, or they already have a huge amount of money in the bank or wherever depositories they may have, pertaining to their own finances. And so the agreement outlines specific financial matters, but some antenuptial agreements will also govern marital behavior like fidelity or define financial risks, should certain behaviors occur. So it depends upon the stipulation of both would-be husband and wife, because this is an agreement prior to marriage. If there are agreements stipulated upon, just as long as they are not contrary to public policy, morals, to the law, of course, and good customs, so that they cannot be void. And there are also examples here of antenuptial or prenuptial agreements I will show you. So these are some of the prenuptial agreement forms that I've searched off the web, because I haven't really seen prenuptial or antenuptial agreement form in the physicality of it in hard copy. So it just states that this agreement has been made on this blank day of blank year by blank and blank. So these are the would-be spouses or the partners, in consideration of the marriage to be solemnized between the parties and of the mutual promises and undertakings set forth below. The parties agree as follows. So on the first format here, you can see there is a disclosure in the first part, and then what is the purpose of the prenuptial agreement, the expiration thereof, if you decide to have an expiration of this prenuptial agreement, for so long as it is not contrary to law, public morals, good customs, public policy. And if we go back to the first one, the disclosure, each party acknowledges that the other has made a full disclosure of all substantially or all of his or her means and resources, and further acknowledges that he or she is entering into this agreement voluntarily and with full knowledge of all of the facts and circumstances relevant to it, exhibits A and B to this agreement. So this is the part where you stipulate that you are aware, or you were made aware of each other's financial capabilities, and you have full knowledge of it. And then there are attachments. So whatever attachments you may opt to put there to prove that there is knowledge from both parties that of your financial capabilities, then you can attach them as exhibits. Second is the purpose. The parties wish to bring about a specific settlement of legal rights in the property and estates to the maximum extent they may do so. If any portion of this agreement shall be determined to be void or unenforceable, the remainder shall continue in effect. So yeah, you actually put in here what is the purpose for the prenuptial agreement, right? So protect their legal rights, each of them, in terms of their property and their estates. Then the third is the expiration. If you wish for this to expire at the rate of how many percent per completed year of marriage. So it depends. If you wish to stipulate an expiration as to the prenuptial agreement, should be binding and valid upon you both. And if there's a legal disability, waiver of the rights here, divorce or legal separation. Divorce is still not legal in the Philippines, but if it is going to be, or if the divorce happens in another country, and if they have validly fulfilled all of the requisites in order to file for a divorce, if they have already changed their nationalities, of course, in order to qualify for a divorce action in other countries. And legal separation, if in case they wanted to have a legal separation between the two spouses, and they can file that here in the Philippines. Now, they can also stipulate the estate at death, what happens to the estate of one spouse if he or she dies, and who shall claim legal rights to the estate, and who shall become the administrator. So it's also noted here the specific gifts, whether or not they will waive, each of the party, whatever gifts that they may undertake or give to each other during their lifetime or at death, which benefits the other party. And then non-probate property, neither party waives the right to receive jointly owned property passing by survivorship, life insurance, retirement benefits, and other property passing at death when one party has designated the other as beneficiary, or when the other spouse is the only permissible beneficiary. So this means that they only receive what was due of them based off of their inheritance from each other, the benefits that either will get from the other upon death of one spouse. And fiduciaries. Okay, so who will be the attorney in fact or attorney at law, who can be trusted, or your confidence in terms of these legal prenuptial agreements. And this is just the first part. And on the other side here, the sample form also, this is a more simpler actually form or format. But this one, I believe, is a prenuptial agreement from the US, because it states here the state of Maine. So let's move forward. These are again another set of antenuptial agreement forms. This is a more simplified though, because it's only one page, and then it stipulates the date, the parties, and the place where they actually contracted this antenuptial agreement. And this is also pertaining to the laws of the state. So this is also an example of a US antenuptial agreement. Here, another example. So there is always a stipulation. Now, therefore, it is agreed as follows. The parties hereby agree as follows. So there must be a stipulation as to the extent by which your prenuptial agreement shall encompass, especially your real and personal properties. So moving forward, as a recapitulation, with regard to the complete separation of property, as their property regime, the following shall remain exclusive property of the owner's spouse under the family code. 1, that which is brought to the marriage as his or her own. Number 2, that which each acquires during the marriage by gratuitous title. Number 3, that which is acquired by right of redemption, by barter, or by exchange with property belonging to only one of the spouses, that being the property as a separate property of that spouse. Number 4, that which is purchased with exclusive money of the wife or of the husband. Now, it is important to note that property purchased before the marriage and fully paid during the marriage remains to be a separate property of either spouse. And if a future spouse sold his property with the right to repurchase before the marriage and reacquired it during the marriage, such property is still the exclusive property of the said spouse. However, if the money he or she paid for the repurchase of that same property came from the conjugal assets, then the said spouse must reimburse the conjugal partnership. Note, however, that if there should be reimbursement, the reimbursement shall be done at the liquidation of the conjugal partnership. So when does it happen? It usually happens during or after the dissolution of marriage. So that's when they will liquidate. Also, it is important to note that in case the property has been donated to or inherited by one of the spouses, as in number 2 here, the said property shall be an exclusive property of such spouse. So accordingly, if someone donates to a married couple a parcel of land, and the said land will not be conjugal, but separate property of the spouse, each spouse owning one half of the property. And if a different proportion or designation of the shares is made, such will be followed. So this happens only when there is a gratuitous title or a gratuitous donation of any property to either of the spouses or to both of them. Now, moving on to the second property regime. This is the one without marriage. So the property regime of unions without marriage, this applies to couples who are capable of getting married, but due to some reason did not get married because the property relations resemble that in conjugal property relations. Now, this means that their possessions prior to the marriage remain theirs, but the properties they produce or acquired during their marriage will be shared equally by both couples. So that's what happens when you have conjugal property of gains. But the property regime of unions without marriage, in here, the properties acquired by common law spouses, because they are not married, right? They're called common law spouses, who are incapacitated to marry each other through their actual joint contribution of money, property, or industry, shall be owned by them in common proportion to their respective contributions. If the actual contribution of the party is not proved, there will be no co-ownership and there will be no presumption of equal shares. So whoever has the benefit of a doubt that he or she has given much contribution, or in fact 100% of the contribution of all the accumulated wealth or estate or real property and personal property, and then there is no presumption of equal shares. If one of the properties is validly married to another, his or her share in the co-ownership shall accrue to the absolute community or conjugal partnership existing in such valid marriage. Now, a question poses, what property regime should govern couples who cohabitate but are not capacitated to marry each other, such as in bigamous marriages or adulterous relationship? The answer to that would be under Article 148 of the Family Code, that states in bigamous marriages, adulterous relationships, or relationship in a state of concubine relationships where both man and woman are married to other persons, multiple alliances of the same married man, or when common law spouses suffer from a legal impediment to marry, or when they do not live exclusively with each other, only the properties acquired by both the parties through their actual joint contributions of money, property, and industry shall be owned by them in common in proportion to their respective contributions. The wages, salaries, and earned by each party belong to him or to her respectively, and in the absence of proof to the contrary, their contributions and corresponding shares are presumed to be equal. The same rule and presumption shall apply to joint deposits of money and evidence of credit. Now, contributions in the form of care for the home, the children, the household, or spiritual or moral inspiration are excluded from the property regime. And thus, if actual contribution of the party is not proved, such as when one party has no salary or income or means of industry, there will be no co-ownership and no presumption of legal or equal shares. So whoever has the most contribution, he is given the presumption of having owned such contribution. Now let's go to the third partnership, which is the conjugal partnership of gains. Now in here, the spouses place in a common fund the proceeds, the products and fruits of their and the income of their separate properties, and those acquired thereafter through their efforts or by chance. Now, conjugal partnership of gains, or CPG as it is commonly known, in here, the properties produced during the marriage will actually go to a common fund, or the conjugal property where both spouses have equal rights. Now, the conjugal property is property here that belongs to the spouses, therefore. There are only three instances that needed to be taken into consideration, especially when we mention CPG or conjugal partnership of gains. First off, in the purchase of property. In conjugal partnership of gains, when there is no showing as to when the property was acquired by a spouse, the fact that the title is in one of the spouse's name is an indication that the property belongs exclusively to the said spouse. But consequently, if a property is purchased partly with money of the wife and partly with the conjugal money, the same is partly conjugal and partly exclusive. So there has to be proper reimbursement in the due course of the liquidation of all the assets of the conjugal properties. So that only happens at the end of or after the dissolution of the marriage. Now, the second thing you have to remember is the presumption of inclusion of property in the conjugal partnership of gains. In here, all property acquired during the marriage, whether the acquisition appears to have been made, contracted, or registered in the name of one or both spouses, is presumed to be conjugal unless the contrary is proved. This presumption of conjugality of properties acquired by onerous title during the marriage arises regardless of the source of funds used to acquire the same. Now, we will go to the third consideration, which is the property on installment. Property bought on installments, paid partly from the exclusive funds of either or both of the spouses and partly from the conjugal funds, belongs to the buyer or buyers if full ownership was vested before the marriage. And the party belongs to the conjugal partnership if such ownership was vested during the marriage. So, for example, prior to the marriage, there was a purchase of a certain property, the money of one spouse and the money of the other spouse. They were used or combined in order to purchase a certain property. Now, if the full ownership was vested or transferred to either of the buyers or both of them before the marriage, then it cannot be considered as part of the conjugal funds. So it can be either exclusively by either of the spouses or perhaps by both of them, depending on the agreement. And if the property was vested ownership during the marriage, even if both of them contributed or either one of them contributed before the marriage, but there was a transfer of ownership during the marriage, then it becomes a property, a conjugal property. It becomes or forms part of the conjugal partnership. In either case, any amount advanced by the partnership or by either or both the spouses shall be reimbursed by the owner or owners upon liquidation of the partnership. So again, by the time that there is a dissolution of the partnership or the marriage itself, then there can be a liquidation of the partnership and its property. So they have the right to reimbursement. Now, the fourth part or the fourth property regime is the absolute community of property. Herein, absolute community of property between the spouses starts from the time the marriage is celebrated. It cannot be modified during the marriage. Hence, any agreement must be done prior to contracting the marriage. Now, starting August 3rd, 1988, the default property regime is already absolute community of property. But again, there can be a prenuptial agreement to allow either conjugal or absolute community, or even separation. Now, under this regime, all properties owned by the spouses before the marriage and those that they acquired during the marriage shall form part of the absolute community and is shared equally by husband and wife. So here, what is yours is mine, and what is mine is yours already. Now, when all properties are acquired by the spouses before their marriage and all the properties acquired during their marriage, it will form part of the whole estate of the absolute community of property. And by virtue of co-ownership, both parties shall own them. When all properties are inherited, donated, or given gratuitously to either of the spouse before their marriage shall be considered as part, again, of the absolute community of property upon marriage and shall be co-owned by both parties. In the event of annulment or legal separation, the regime of absolute community property shall not be affected and will remain owned by both spouses unless they have filed for judicial separate of properties or judicial separation of properties. And in case there is a judicial separation of properties, the properties within the absolute community shall be split between the husband and wife. Now, to make it quick and concise, prior to August 3, 1988, what governs your marriage is the CPG. But after that, August 3, 1988 onwards, the absolute community of property. So the main difference here is in CPG, the houses retain ownership of their properties prior to the marriage. Only the fruits and the income of the above property shall form part of the CBG or the conjugal partnership of gains pool. Now, in absolute community naman, spouses become co-owners of all their properties. This is the default property regime upon marriage, even pertaining to properties that they have acquired prior to the marriage. But for both CPG and absolute community, all properties acquired during the marriage form part of the pool. Now, while there is no greater risk than matrimony, there is nothing happier than a happy marriage. So before you get married, you guys, please decide on which three regimes available for you shall you allow to govern in your marriage prior to getting married. Going back to question or bar question number 6, name at least two exclusions from the following property regimes as enumerated under the Family Code. Letter A, absolute community of property. Now, suggested answer may be any two of the three may be considered. Number 1, property acquired during the marriage by gratuitous title by either spouse and the fruits as well as the income thereof, if any, unless it is expressly provided by the donor, testator, or grantor that they shall form part of the community property. Now, number 2, personal property for personal exclusive use of either of the spouse. However, jewelry shall form part of the community property. And number 3, property acquired before the marriage by either spouse who has legitimate descendants by a former marriage, and the fruits as well as the income, if any, of such property. Another letter B for us to conjugal partnership of gains. Suggested answer may be number 1, property which is brought to the marriage as his or her own. So this form part of their separate personal property. Number 2, property which each acquires during the marriage by gratuitous title. Number 3, property which is acquired by right of redemption, by barter, or by exchange with property belonging to only one of the spouses. And number 4, property which is purchased with exclusive money of the wife or of the husband. So again, these are exceptions pertaining to separate property. Now let's go to question number 7. Believing he owned a certain parcel of land and completely unaware of any defect in his title thereto, Mr. A started to build a house thereon. When Mr. P, the real owner of the land, learned of Mr. A's actions, Mr. P immediately demanded Mr. A to leave the premises. However, Mr. A refused to leave and instead asserted that as a builder in good faith, Mr. P is obliged to sell the land to him. Is the claim of Mr. A correct? Can you explain? The answer to this bar question is no, Mr. A is not correct. Mr. A, who was completely unaware of any defects in his title, is a builder in good faith. Mr. P, who is the real actual owner of the land, prompted Mr. A's possession, also acted in good faith. Article 448, the new civil code applies in this case, which provides that only the owner of the land on which anything has been built, sown, or planted in good faith has the right to appropriate as his own the works, sowing, or planting after payment of the indemnity for necessary expenses and useful expenses where applicable, or to oblige the one who built or planted to pay the price of the land and the one who sowed the proper rent. However, the builder or planter cannot be obliged to buy the land if its value is considerably more than that of the building or of the trees. Now, the law grants the said right to the owner of the land. Now here in this case, the builder in good faith, Mr. A, cannot compel Mr. P, who is the real owner of the land, to choose which rights to exercise, because this option to exercise the right is explicitly provided in the article that belongs only to the real owner, who is Mr. P. So only he, Mr. P, can choose whether he wants um, to either sell the land to Mr. A, or if he wants to appropriate all the necessary expenses and indemnify Mr. A such that he may acquire back the land. Now, there's also an alternative answer to that question. No, Mr. A is incorrect. He is a builder in bad faith. When Mr. A started building his house, he was completely unaware of any defect in his title and therefore was, at the outset, a builder in good faith. But when Mr. P immediately demanded Mr. A to leave the premises before he completed the house, so this is in the case where the house wasn't complete yet, and he was asked by Mr. A to leave or vacate the premises of his land, to which Mr. A refused. And he continued building since he persisted in the belief that his title to the land had no fatal defect. He became a builder in bad faith because there's already knowledge that somebody was claiming ownership of the land even prior to the accomplishment of the building construction. Now, he became builder in bad faith in this case. Mr. P, the real owner, who immediately asked him to leave the premises, acted in good faith. Of course, any owner of a certain property, especially a real property, would really want to have acquisition and possession of his property. Therefore, those who are encroaching on his property, he would want them to vacate the premises. So he's only acting in good faith. He has by law the option of acquiring the house without paying for it. So this is another alternative answer to that, because builder in bad faith and the owner in good faith, the right of the owner in good faith here shall supersede. Therefore, he has the option of acquiring the house even without paying for it, because that house is built on his land and the house is built by a builder in bad faith. All right, moving on to the continuation of that particular case. Assuming, letter B, that Mr. P all the while know but did not object to Mr. A's construction of the house on his property, may Mr. A compel Mr. P to purchase the said improvement due to Mr. P's bad faith? Explain. So in this case, the answer is yes. Mr. A may now compel Mr. P to purchase the improvements, which is the construction of the building or the house itself, because according to Article 454 of the Civil Code, when the landowner, Mr. P, acted in bad faith and the builder, planter, or sower proceeded in good faith, with full knowledge that Mr. P is aware of his constructing the building on his property or land, then the provisions of Article 447 shall apply. In Article 453, it is understood that there is bad faith on the part of the landowner whenever the act was done with his knowledge and without opposition on his part. So there was prior knowledge and he did not contest to it. Even, in fact, he probably even agreed to it, to the building of or construction of the building on his property. Then that owner acted in bad faith. Article 447 provides that the owner of the land who makes thereon personally or through another plantings, constructions, or works with the materials of another shall pay their value. And if the landowner acted in bad faith, the owner of the materials may remove them in any event with the right to indemnify or to be indemnified for damages. Now, the landowner here, Mr. P, having known and without opposing, not even contesting the construction made by Mr. A, is deemed to have acted in bad faith, as in this case. Therefore, Article 447 applies, and Mr. P shall pay the value of the improvement, including the value of the materials plus the damages. That is, if in the case that he still wants to evict Mr. A and compel him to vacate the premises. There's also an alternative answer to that, which is a simpler one, since Mr. A is a builder in bad faith for continuing to build despite being asked to leave the premises, and Mr. P also acted in bad faith for not objecting to Mr. A's construction of his house on his property. Then they should be treated to have both acted in good faith. So, bad faith minus bad faith equals good faith, or actually, bad faith plus bad faith equals good faith. Their act, both has become neutralized, for both having acted in bad faith. Now, the article here that applies is 448. The two options still belong to Mr. P and not to Mr. A. Let's proceed to question number 8. Mr. E leased a piece of land from Mr. F to be used for his sawmill business for a period of 10 years, and consequently, Mr. E placed heavy machineries thereon to be used for his aforementioned business, with the intention of removing them after the expiration of the lease period, which is 10 years. Are Mr. E's heavy machineries considered real properties under the Civil Code? Explain. The answer to that is no. They are actually movables. Machinery which is movable in its nature only becomes immovable when placed in a plant by the owner thereof in a land or building which is also owned by him, for an industry or works which may be carried on in a tenement and which tend directly to meet the needs of said industry or works, but not when so placed by a tenant, a usufructuary, or any person having only a temporary right, unless such person acted as the agent of the owner. For instance, if the lease contains a stipulation that any useful improvement which the lessee introduces on the leased property shall pertain to the lessor at the termination of the lease. Here, the heavy machineries were placed by Mr. E on a piece of land leased from Mr. F, who is the actual owner of the land, with the intention of removing them after the expiration of the lease period. So Mr. E here placed these movable machineries with the intention of, after the expiration of their lease, he will remove them from the premises because the contract has already expired. Now, being movable in nature, these machineries were not deemed to be immovable. Okay, this is the case of Davao Sawmill Company Incorporated versus Castillo. Moving on to question number 9. Miss U is a usufructuary of a piece of land owned by Mr. L. During the existence of the usufruct, Miss U introduced various useful improvements on the land. Upon termination of the usufruct, Mr. L requested Miss U to remove the said improvements, but Miss U refused, demanding instead that Mr. L reimburse her the value of the same. Now, what is a usufruct? The answer to that is a usufruct gives a right to enjoy the property of another with the obligation of preserving its form and substance, unless a title constituting it or the law otherwise provides, as in Article 562 of the New Civil Code. The court has further declared that a usufruct, in essence, is nothing else but simply allowing one to enjoy another's property. It is also defined as a right to enjoy the property of another temporarily, including both the jus utendi and the jus fruendi, plus impliedly the jus possidendi, with the owner retaining the jus disponendi or the power to alienate the same. This is as in the case of moralidad versus spousus perines. So we will further discuss a little bit about the details of usufructuary in the next slide. So now we come to ask, what is a usufruct? A usufruct, the word usufruct comes from usus, meaning the usage or the right to use or enjoy a thing possessed directly and without altering it, and the other term called fructus, or the fruit, in a figurative sense, meaning the right to derive profit from a thing which is possessed, for instance, by selling the harvest, renting the real estate or the devices, and taxing for entry. Now, Usufruct in general is stated in Article 562 of the new Civil Code, which simply provides that usufruct gives a right to enjoy the property of another with the obligation of preserving its form and substance unless the title constituting it or the law otherwise provides. Now, this right to enjoy the property of another with the obligation of preserving its form and substance is a requisite unless there's a stipulation contrary to that, or if there is a provision in the law otherwise. The formula for usufruct here is jus utendi and jus fruendi equals usufruct, whereas jus disponendi equals naked ownership. So let's discuss further about that. There are three fundamental rights according to the Civil Code appertaining to ownership. There is first the jus disponendi, or the right to dispose of a thing. So you can sell it, dispose of it, whatever you want to do with it as an owner. Number two is jus utendi, or the right to use of a thing. And number three is jus fruendi, or the right to the fruits of that thing. Now, again, you have to bear in mind the formula that if you are talking about usufruct, it's basically the right to use a thing and the fruits of the thing, or to make use of the fruits of the thing, but it doesn't mean, or it does not include the jus disponendi, or the right to dispose of the thing, because it's just a temporary usage of the thing that you are enjoying, right? Given to you by the owner. Because jus disponendi, this is the essence of naked ownership, retains to the owner of that thing or property. Again, the formula for the ownership here as to whether it's naked, it's full ownership, or if it's a usufruct. If it's full ownership, it means that you have the naked ownership there, which is jus disponendi, or the right to dispose of a thing. Plus, you also have the usufructuary rights, which is the jus utendi and jus fruendi, meaning the right to use the thing and the right to the fruits of the thing. So that's full ownership. All of those three rights therein are being exercised by the owner in full ownership. Now, in naked ownership, on the other hand, this is full ownership. So all of those three rights minus the usufruct. So basically, it's just minus the jus utendi and minus the jus fruendi, because the usufructuary has the one who is the one who is exercising those rights, the utendi and fruendi. That's why it's full ownership minus usufruct. That is what we call naked ownership, or the right to dispose only, which is disponendi. Now, in usufructuary, again, if you do it on the other or vice versa, so you use full ownership, you subtract it with naked ownership, which is jus disponendi, and then there you go, you have usufruct, which is the right to the fruits and the right to the usage, utendi and fruendi. Okay, so let's, if everybody got that right and easily, let's move forward. So to distinguish usufruct versus ownership, usufruct is just a limited enjoyment of the property. So again, jus utendi and jus fruendi, the rights to use the thing and the fruits of the thing. Whereas ownership has the following attributes: the right to enjoy, which also includes jus utendi, fruendi, and abutendi, and the right to dispose, which is disponendi, also the right to vindicate or recover the property, which is jus vidicandi. So going back to question number 9, and this time letter B, is misuse demand proper? Explain. The suggested answer to that is no, the demand is not proper. The Civil Code provides that the usufructuary may make on the property held in usufruct any useful improvements or expenses for mere pleasure, which he may deem proper, provided that he does not alter its form or substance, but he shall have no right to be indemnified therefor. He may, however, remove such improvements should it be possible to do so without injury to the property. This is in Article 579 of the new Civil Code. Thus, Miss Yu has no right to be indemnified for any improvements which she might have made on the land held on usufruct, since the enjoyment of the land itself was only for temporary use. Now, her only recourse is to remove them, such improvements, if it is possible to do so without injury to the property. Number 10, Village H and Village L are adjoining residential villages in mountainous portion of Antipolo City, Rizal, with Village L being lower in elevation than Village H. In an effort to beautify Village H, its developer X Incorporated constructed a clubhouse which included an Olympic-sized swimming pool and an artificial lagoon on a portion of land overlooking Village L. During the monsoon season, the continuous heavy rains caused Village H's swimming pool and artificial lagoon to overflow, resulting in a massive spillover that damaged various properties in Village L. Aggrieved, the homeowners of Village L filed a complaint for damages against X Incorporated, the developer. In defense, X Incorporated contended that pursuant to the Civil Code, Village L as the lower estate was obliged to receive the waters descending from Village H, the higher estate. Hence, it cannot be held liable for damages. Is X Incorporated's position tenable? Explain. The suggested answer to it is no, X Incorporated's position is not tenable. The Water Code provides that lower estates are only obliged to receive waters which naturally and without intervention of man descended from higher estates. That is in Article 50 of the Water Code of the Philippines. The code also provides that the owner of the higher estate cannot make works which will increase the natural flows. So, if there is such a thing as a natural flow of water from the higher estate to the lower estate, there should be no works or intervention made by man that will increase such flow. Therefore, Village L as the lower estate was only obliged to receive the waters which naturally and without intervention of man descended from higher estates and not those which are due to massive spillover from constructions made by X Incorporated. This is in Article 537 of the new Civil Code. Therefore, X Incorporated is liable for damages. Thank you all for listening. Let's proceed to the next reporter.